Yeah, they always forget to turn that TV. They always forget to mute it. I muted it. This needs to be muted.
Good afternoon, Your Honor.
If I carry them on you all the time.
Go to my office. I think we have a box of them. You want to run back to my office?
Where's that?
You know where the admin area is? You know where the restrooms and the kitchen area are? It's the only office back there by the men's room.
Okay, so I have to go through that one more time.
And if it's locked, then my partner's not in there, but if she's in there, we've got a box full of batteries.
Okay.
And if not there, on your way back, check with Karen and Stacy up front.
Let's try this again. 3, 2, 1. Let's go. Deputy Revocation. Are you ready, ma'am?
I am ready. We don't have our bodies yet. As you know, we had some technical issues that we just got fixed at the final moment, and now they're bringing the bodies up, but they are not here yet.
Let me have Mr. Ashmore who just walked in. I've got Mr. Nichols here, and we can go ahead and knock that out. All right. And Mr. Nichols, can you see Mr. Okay, let's fix this TV. All right, can you see Mr. Ashmore there and also on your computer right there? Yes, sir. Okay. All right, Mr. Ashmore, this is cause number CR2187, State versus Jason Eric Nichols, and we are set for docket call. Do you have an announcement, Mr. Ashmore?
Yes, Judge, my apologies for Mr. Nichols not being here. He had some misunderstanding, and I know he's got a health issue that he told the probation department about. Judge, you had given us a reset to get his Veterans Court application completed and to the Veterans Court. Our first available opportunity to do that was last Friday. Mr. Nichols' phone was shut off in the month of November, and he has the application. I don't have it back yet. I would still like the opportunity to get him into Veterans Court because he's eligible and he's asked the court to have that opportunity to get those services. I need that application, and I can present it as quickly as possible to the coordinator, Ms. Brendan Rivera Jones, but I need a completed application from him. So I know we already got a reset for that. It is a long application. It's not the easiest thing in the world to fill out, and I don't have it yet. So I'll take responsibility for that. And about the confusion for today, we'll just ask the court for a docket call reset. Let me get him that application filled out and to the Veterans Court coordinator. See if we can get this case moved over there.
We've been on docket call since August. That's my only concern is we started August, September, 2 in September, October, December. We're gonna spend over 6 months on docket call.
I get that, Judge.
I'll tell you what I'm gonna do. I'm gonna go ahead and just set it for jury selection, and then in the meantime, if you and the state work something out, you'll let me know, and I'll consider whether or not I let him plead contrary to my policy. Okay?
I appreciate that, Judge. You understand that, Jason?
Yes. So what I'm gonna do is I'm gonna set you for jury selection beginning January 10th. So what you'll do is you'll report to the courthouse in the basement at 8:30. I'll have one of my court staff members down there, and she'll help you with the paperwork, give you the reset. You will not go to trial on the 10th, and Mr. Ashmore will not be required to be down there on the 10th. And you won't report up here because we will be picking a jury for another case. You'll continue to do that each month until your case is reached for trial or until it's resolved, okay? All right.
Thank you very much.
I've got one here. I'm gonna have it fill out a notice of appearance here.
Oh, all right.
I do have the application fully completed. I just had to send it. And the sheriff's department had my phone until a few days ago.
Judge, may I speak to Mr. Nichols while we're on the Zoom here?
Yes, just
Nothing
know,
privileged.
just know it's not privileged and you're streaming.
Jason, if you can come over to the Justice Center, the Sheriff's Department, meet me out in the parking lot, okay? All right, thank you. Thank you, Your Honor.
You're welcome.
Thank you, Ms. Heisel, Mr. Woodwhite.
All right, Mr. Nichols, I'm gonna have you sign here. And we'll give you the other copy.
Froze up on our end, Judge. Am I excused for a moment?
Yes, yeah, Mr. Nichols is signing and he's free to go.
Thank you, Your Honor.
You're welcome.
Okay, thanks, Judge.
And court, for the record, will withdraw the NICI and CR 2187. Jason Eric Nichols.
Just give it to court.
I don't know.
I mean, we worked for a
I
while.
have several phones. I don't know. So I probably got locked up. I had a flip phone I forgot. And I broke it. So I don't have no electronics in my property. I don't know. I had a pair of Levi's boots, no work clothes. So I'm talking about in general. Oh, I'm talking in my face. Yes, sir. so then maybe I'll come visit you either after your completion. If I don't want to- Okay. Well, if there's anything, I feel like there's some stuff in my property that I'm putting in, since I've been not incarcerated. And I don't know if that's could be from pictures, it could be important information documents. Is there any way I can get any of that? Or know if that's in, if that's there, so I mean, all of it. I'm looking for all the pants and clothes like.
Your Honor.
All right, Ms. Beasley, who do you have with you? Is this Austin Walker?
It is, Your Honor.
All right, this is cause number CR 2200 and 232, State versus Austin Lynn Walker. We're set for status, I believe, on plea.
That is correct, Your Honor. It's my belief after discussing this case with Ms. Curry that there is an excellent chance that we will be able to resolve this at additional future setting. Hopefully the court to be willing to set this on January the 4th, and we'll know if we'll be able to resolve this during my representation of Mr. Walker.
State, do we believe January 4th will be enough time? I know that there's a timing issue with the co-defendant's case.
Yes, Your Honor, the co-defendant is set to plea on Thursday, as long as of this week, as long as everything goes according to plan. Mr. Walker will be ready to go in January.
Okay, Ms. Beasley, court will set him for status on plea for January 4th at 1:30.
May he be excused?
Yes, ma'am. Thank you.
Thank you, Your Honor.
Is that all you have, Ms. Beasley?
No, Your Honor, I have Mr. Ellis as well.
Oh, okay. I don't see him.
He's,
I thought we've already reassigned him a new attorney. Have we not?
does have an attorney, but I believe we said it. He's here in the courtroom, Judge.
Oh, yeah.
Well, he is, I guess, listed as Mr. Sanders. I just guess that the formal handoff, I've already turned over all of the information I have on the case, all the discovery, as well as the trial notebook that I had begun to prepare for Mr. Ellis. So I guess now, if Mr. Sanders has any questions, he's got my number. He can get a hold of me if he has any additional questions, Judge.
All right. So for the record, this is, and Mr. Ellis, come on up. This is cause number CR 19305, State versus Donald Brian Ellis. The court has granted Ms. Debbie Beasley's motion to withdraw. The court has appointed Mr. Jeff Sanders as counsel for Mr. Ellis. Mr. Ellis, you are aware that Ms. Beasley was, she is retiring from practice, and that is what has necessitated you receiving a new attorney, because your case is not resolved within the time period that she's closing her office and retiring. So Mr. Jeff Sanders has been appointed as your new counsel, and you've heard on the record Ms. Beasley state that she is transferring all of the file and all of the things, work product that she has done on behalf of you to Mr. Sanders. And Mr. Sanders, we were set for docket call today. And correct me if I'm wrong, Ms. Beasley, while you're here, we haven't set Mr. Ellis for trial yet, have we?
No, Your Honor. He was considering whether or not he wanted an additional DNA test to compare the male DNA that was found as evidence to whether or not he wanted that actually compared to him with YSTR testing.
Did we ever get a resolution on that?
No, sir.
Okay. Mr. Sanders, go ahead, Mr. Sanders. Go ahead, Mr. Sanders.
Yeah, I would just ask if we could reset it for another docket call, so sit down with Mr. Ellis and start going through things and ask him, if that's something that we would need to pursue.
All right, court's going to reset this case for docket call on February 8th at 1:30. I would anticipate that if we don't have some kind of request or need to for additional testing or some of the pretrial issue, that we would set it, we would specially set it for jury selection on that date. This is a aggravated sexual assault, so it would take priority, and Mr. Ellis has been in custody for quite some time, so I would set this for a preferential trial setting in 2022. All right, so we'll see you back on February 8th, Mr. Ellis. Mr. Sanders, do you have any of your other clients in the jail?
Sure, I'm ready on Mr. Vance.
Okay, yeah, I don't know, so go ahead and just bring up, go ahead and bring up who you got. This is CR 2140, State versus Terry Glenn Vance.
And Judge, I think you should also see CR 21-00344. There's a new evading with the vehicle that just recently got indicted. So I was thinking that today That one was set for,
Pretrial.
yeah, well, either arraignment or pretrial. I tried to file a waiver of arraignment last month and the e-filing system rejected it and said that today was actually the arraignment date. Cause I had put on the waiver form a different, I think I put on today for the pretrial date, but what notice I got back said that today was actually going to be the arraignment date. So I'm not sure exactly.
I show that he was set for arraignment October 28th. That's when we sent a notice of arraignment out, and it looks like there was a surrender of principal. My system says that it was set for arraignment 10/28 and then pretrial today.
That's what
But I don't see an appearance on this case before. So let's just go ahead and do you have an indictment with you there? If not, I can have one.
And Judge, we've well, he actually signed a waiver of arraignment, but Judge, Mr. Vance's name is spelled correctly. We would waive the reading of the indictment, waive the formalities of arraignment. He understands the charge, what he's charged with, punishment range, and we enter a plea of not guilty at this time.
All right, the court will enter Mr. Vance's plea of not guilty into the record. Court will set this matter for pretrial on February 8th at 1:30 if he's in jail, 9 a.m. if he's on bail, and we'll set the other case for docket call same day, February 8th. Have you already received discovery on the new evading charge?
Yes, sir. I have the written discovery. I think I still need to get the whatever audio video recordings. I think the discs I have are just from the first case.
Okay, if you'll make sure that we go ahead and try to secure that from the state so we can be ready for pretrial on the 8th.
Judge, I will speak with my office, make sure those are copied. Hopefully we can have Mr. Sanders, those available for Mr. Sanders this afternoon.
Thank you, Mr. Woodwine. Is that all you have today, Mr. Sanders?
Yes, sir. It is. Might be excused.
Yes, sir. Thank you.
Mr. Adams, when you're ready to step on the podium, and I'll get you mine.
All right, who do you have, Mr. Ashmore? Is this Mr. Schultz or Mr. Foster?
This is Mr. Foster, Your Honor.
All right, CR 21-214, Stephen Leslie Foster, set for pretrial.
Thank you, Your Honor. On behalf of Mr. Foster, Your Honor, I don't have any pretrial issues to take up today. What I need to inform the court of is that I've received a plea offer in Mr. Foster's cases, or case, late yesterday afternoon. I have just now told him what that offer is. He and I need to discuss that more in depth so that I can cover the pros and cons of it, whether or not he wants to roll the dice and go to trial. I would ask the court's indulgence for one more setting before we put on a jury trial docket. And I realize I've had this, I think, since September.
All right, court will set Mr. Foster. Are you available on, I mean, we're set for pretrial today, so there being no contested pretrials, the court will set this for docket call. I can set you the 25th, or I can set you the February 8th. I can set you sooner if you want it. I don't know what you're looking for. I mean, I've got January 4th, January 6th.
Hang on a second. Let me listen to your bullshit. Sorry about that. I should have had this with my calendar. Okay. We're done. Just chill out. Those dates, I'm sorry, Your Honor, could you repeat those dates again?
So we can get him as soon as January 4th in the afternoon. We could do January 25th, February 8th. You're back on the 8th on an earlier case, but that's setting him out an additional.
Yeah, that's pretty far. And
25th?
I think I'm here that day anyway, Your Honor, so the 25th would be fine.
All right, court will set Mr. Foster for docket call January 25th at 1:30. Deputy McLeish,
Yes, Your Honor.
are we having any issues over there?
Not anymore.
You will be sure to let me know if we are, because I'd like to be a solution to that.
Yes, sir. You can just sit on the table.
Is Mr. Schultz ready?
He is here, Your Honor.
It's cause number CR 21-243 and 2020-513, State versus Billy Joe Schultz, set for docket call.
Good afternoon, Your Honor. Mitch Adams on behalf of Mr. Schultz. My docket call announcement is that I received a plea offer for Mr. Schultz's cases just yesterday afternoon when I received the other ones that I've advised the court of today. And as in those other cases, for Mr. Schultz, I would ask that the court give us one last setting prior to being placed on a trial docket so that I can visit with him about what those offers are. He and I can decide what to do.
State, do you have any objection?
State has no objection, Your Honor.
All right, court will set Mr. Schultz for docket call on January 25th in both cases.
That'll conclude my announcement for Mr. Schultz, Your Honor. And I think you and Ms. Beasley had already addressed Austin Walker.
Correct.
Okay. Then I
Right. Yes, Mr. Walker is being set on January 4th to enter a plea if contingent upon another case resolving on Thursday.
Right, okay. Then I think that's all I have on the docket. Your Honor, may I be excused?
Yes, thank you, Mr. Adams.
Thank you, Your Honor.
Your Honor, we have concluded all the business with the people who are in the room, and now I've got some staffing issues. So if you could let me mute for a few minutes, and then we'll get some bodies up here.
Yes, ma'am.
Thank you.
You're welcome.
And Your Honor,
Yeah,
Okay.
well, I got arrested under Huddle, but my married name was actually Pope, but my husband's died now.
It's been almost 2.5 years since we've seen each other.
Yes, sir.
So our offer's gotten a lot worse. We had a 2-year offer, now it's 4. Changing the policy of the district attorney's office, and so nothing's gonna happen today, but we're gonna be reset on that motion to adjudicate, okay?
Why does anything count towards me being here? I'm supposed to be having surgery. A module valve in the heart is leaking.
Mr. Ashmore,
Yes, ma'am.
I just wanted to let you know that you guys aren't on mute, so I just wanted y'all to be careful about what you let the DA's office over here.
Yes, ma'am, thank you.
Casey, if you want to mute it until the judge.
Yeah, that's fine.
Stimulate that mouse.
Yes, ma'am.
See the bottom left-hand corner.
We're just gonna.
Your Honor.
Get a reset.
Yes, Your Honor, I'm ready.
Okay, Mr. Ashmore and Ms. Pope are here for you.
Move that podium, Judge.
All right, who is
Judge,
it?
this is Stacy Heidel. She also goes by her married name of Pope.
All right, this is CR 1411. Go ahead. This is a hearing on motion to revoke.
This is Judge, it's been a long time, almost, I think, 2+ years since we've been in court over Ms. Heidel. We had an offer previously of 2 TDC for not complying with terms of probation. It's now an offer of 4. I'm going to ask the court just to set this for a contested so I can work with Ms. Heisel on what we can do to resolve this matter. Ms. Stacy has some significant health problems. I'd like to get some more information on that, talk to the state about it, and see if we can come to a resolution before or at our next hearing.
Okay. Let's see, the next contested docket I have will be January 27th. That would be in the afternoon at 1:30.
All right, Judge, thank you. And I'll make a request for some updated information on the MPR. I know Ms. Heisel showed me the one from 2019 earlier today, and I know they're working to figure out what else needs to be revised on or amended on that. So if I can be excused for a moment, Judge, I'll have her sign this and we'll get her back.
Yes, sir.
Okay, thanks, Judge. Get your feet up. Okay, I'm gonna put this right here where you can, right or left handed, remind me.
Left.
Your Honor,
Yes, ma'am.
we do have Ms. Gonzalez in the room. Would you like to visit with her?
Yes, yes, please.
Ms. Gonzalez, come on up here.
All right, this is cause number CR 2166, State versus Jennifer Lynn Gonzalez. Ms. Gonzalez, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams. If convicted and sentenced by a judge or a jury, Ms. Gonzalez, the range of punishment would be confinement in the Texas Department of Criminal Justice for not less than 2 years or more than 10 years, and a fine not to exceed $10,000. Do you anticipate hiring an attorney to represent you? Do you want to represent yourself? Are you requesting court-appointed counsel? Are you
I'd like to hire an attorney myself.
going to represent yourself?
No, I'd like to hire an attorney.
Oh, I'm sorry. I'm sorry. You'd like to hire an attorney. How soon can you have someone hired?
Within a month.
Do you have money?
I have a little bit of money, but it's money that I need to use to bond out. I was gonna ask if we could be able to have a bond reduction.
Well, I would only entertain a bond reduction if it's filed by an attorney. Because there's gonna have to be certain testimony that's gonna have to be given. So if I reset you for a month, do you have family or anyone that's gonna be helping you call attorneys and get them hired? And
No, it was all based upon getting a bond reduction because whenever they arrested me, the arresting officer, I gave him my purse, but he didn't bring anything to jail with me. I have no numbers. I have no way to contact anyone. I have nothing. I have one ex's number and I've called to him since I came into here to try and receive some kind of help and to get me numbers that I need, but he's been unsuccessful.
prior to you being arrested, did you have a job?
Yes, sir.
Okay, what kind of work did you do?
Healthcare, like home health.
Well, are you a nurse?
No, sir, it's just like for the elderly and things like that. It's more of cleaning and just going in, checking on them on the daily, that sort of thing.
How much money do you have saved up?
I have $700.
And you think within a month's time, you're gonna be able to save up a couple $1,000s to be able to hire an attorney? Okay, all right, so what I'm gonna do, Ms. Gonzalez, is I'm going to reset you until I'm gonna reset you till January 25th.
Thank you, sir.
It's a little over a month, and if you don't have an attorney hired by then, we'll have to talk about it again at our next hearing, okay?
Okay. Were we able to work a bond thing, or was that only with the lawyer? The bond reduction?
I'm only going to entertain a bond reduction when you have an attorney who's going to have to put you under oath, ask you a series of legal questions in order for the court to consider that. So either you're going to represent yourself and you file your own motion for bond reduction and you subject yourself to cross-examination by the state, so on and so forth, or you hire an attorney.
Okay, thank you.
Okay, it'll be just a few minutes, Judge.
In your honor, Judge Martin. You pulling that door closed, Patty? Thank you. We are unmuted and I've texted him. So I expect he's probably taking care of something.
I suspect so.
I'm sorry, Mr. Stevens, I haven't looked over this, may I?
Yes, please.
All right, I'm ready. Sorry about that. Mr. Stevens, who are you ready on? You ready on your plea or someone else?
We're ready on my pleas, Your Honor. James Derringer to be first.
Mr. Darren, come on up, sir.
All right, this is CR 21163, State of Texas versus James Michael Derringer. And I'm not sure if I have, the only plea papers I think I have, double check. Shay. That's from Mr. Ashmore. Do you have the plea papers there with you, Mr. Stevens?
I do, Your Honor.
All right, if you could just tell me the terms, Mr. Stevens.
Yes, Your Honor. The terms will be for 4 years in TDC, $2,500 fine. Looks like reimbursement fees of $20. Court cost of $290. And 1245, case that's not filed, DA number 2021-0462, which is a fraudulent use of identifying information.
All right, any credit time for Mr. Derringer?
Yes, Your Honor. 248 days as of today.
All right, he's going to be pleading guilty to the charge as indicted, forgery of a governmental or national instrument, money, or security.
Yes, sir.
All right, Mr. Derringer, sir, if you will raise your right hand, I'm going to place you under oath. Mr. Derringer, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may put your hand down.
Yes,
Mr.
down because he has bad legs.
Yeah, that's fine. Not a problem. Mr. Derringer, is your name James Michael Derringer?
Yes.
And Mr. Derringer, are you a United States citizen?
Yes.
Do you read, write, and speak English?
See.
Have you ever, that's not funny. Have you ever been diagnosed with well, it's a little bit funny. Have you ever been diagnosed with a mental condition?
No, sir.
All right. In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation?
Yes.
And do you feel like you have understood everything that you have read, reviewed, and signed today with him?
Yes, Your Honor.
Is that your true and correct signature in the documents?
Yes.
Mr. Stevens, have you explained all of the legal rights to your client?
Yes, Your Honor, I have.
Do you believe he understands them?
Yes, Your Honor, he does.
And you believe him to be competent today?
Yes, sir, I do.
All right, Mr. Derringer, you are charged with forgery of a governmental or national financial instrument, money, or security. That is a third-degree felony. It does carry a range of punishment of not less than 2 years or more than 10 years, and a fine not to exceed $10,000. You understand the plea agreement that Mr. Stevens read to the court? Is that what you are asking the court to approve today?
Yes, Your Honor.
Then at this time, Mr. Derringer, how do you plead? Guilty or not guilty?
Guilty.
Are you pleading guilty because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
All right, court accepts the defendant's plea of guilt. Mr. Stevens, any objection to the state's evidence?
No objection.
All right, state's evidence is admitted. Court takes judicial notice of the defendant's judicial confession. State, can you give me the evidence to support the plea?
Yes, Your Honor. The bank located inside the Canton Walmart got alerted by one of the tellers that there was a gentleman there trying to make a withdrawal of $4,000 from an account with an ID matching that bank account holder. However, that teller just happened to know the bank account holder and knew that the person trying to withdraw that money was not the true holder of that account. They detained him. It was Mr. Derringer. They detained him. He gave a statement, a story about how he had come to be there with that fake ID and the circumstances. However, I think there are other cases in the Metroplex involving this same victim who is, I believe, 77 years old, where Mr. Derringer is trying to pass for him in multiple different jurisdictions. So we have filed a forgery charge against him, and then we will be 1245ing the fraudulent possession of identifying information.
Mr. Stevens, any objection to that summation of the evidence?
No objection.
All right. The court finds that there is sufficient evidence to convict Mr. Derringer of this offense. The court will follow the plea agreement. Court assesses punishment. The court does convict Mr. Derringer of forgery of a governmental or national instrument of money or security. The court assesses his punishment at 4 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders him to pay a $2,500 fine, $20 reimbursement, $290 court cost. Court dismisses under section 1245 DA 2021-462. The court awards Mr. Derringer 248 days credit towards his sentence for the time that he has spent in jail on this cause. Court hereby remands Mr. Derringer to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Mr. Derringer, I'm going to have you go with the deputy there to be fingerprinted. Good luck to you, sir. Adios.
Mr. Derringer, you're here with me, sir. Mr. Stevens. Thank you. And may I take this?
Yes, please.
Mr. Derringer, I need you to step over here with me. Mr. Stevens, before you get Mr. Simmons up, just a really quick. This one. Mr. Simmons. Can I take you in?
Sorry about that, Mr. Stevens. Who do you have with you now?
I have Steve Simmons, Your Honor.
All right, CR 2365, State versus Steve Leonard Simmons. Are we doing a plea on this case as well, Mr. Stevens?
Yes, Your Honor.
All right, can you tell me the terms?
Yes, Your Honor. He's charged with a first-degree felony of delivery marijuana over 50 pounds, less than 2,000 pounds. The plea agreement is for 5 years TDC, $7,500 fine, $180 in restitution, $85 in reimbursement fees, and he has 131 days credit as of today. And let me back up, Judge, $290 in court costs.
Any other cases that were taken care of?
No, Your Honor, just this one.
All right, so 5 years TDC, 7,500 fine, restitution, reimbursement, court costs, 131 days credit. Okay.
Yes, sir.
All right, Mr. Simmons, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, maybe put your hand down. Your name is Steve Leonard Simmons, is that right?
Yes.
And Mr. Simmons, are you a United States citizen?
Yes.
Do you read, write, speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation of you?
Yes.
Like you've had enough time to discuss your case with him, have all your questions answered?
Yes.
Is there anything about the paperwork that you've read and signed today that you do not understand? And does the documents bear your true and correct signature?
Yes.
Mr. Stevens, do you believe Mr. Simmons to be competent today?
Yes, sir, I do.
You've explained to him all of his legal and constitutional rights,
Yes, sir, I have.
and do you believe that he understands them?
Yes, sir, he does.
All right, Mr. Simmons, the charge of delivery of marijuana 50 pounds, but less than 2,000 pounds is a first-degree felony. It does carry a range of punishment of confinement in the Texas Department of Criminal Justice for not less than 5 years or more than 99 years or life, and a fine not to exceed $10,000. I see here that the proposed plea agreement that Mr. Stevens has read to the court would fit within that range of punishment, and is that what you're asking the court to approve today?
Yes.
Okay. All right, so at this time, Mr. Simmons, how do you plead to delivery of marijuana greater than 50 pounds, less than 2,000 pounds?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court accepts the defendant's plea of guilt. Mr. Stevens, any objection to States 1?
No, Your Honor.
All right, States 1 is admitted, and the court takes judicial notice of the defendant's judicial confession. State, will you give me the evidence to support the plea at this time?
Yes, Your Honor. The highway patrol makes a traffic stop because a vehicle is failing to maintain a single lane on the highway. The reason for this is that there is a 15-year-old female driving the motor vehicle. There are 2 female passengers of the vehicle as well as Mr. Simmons. The only thing that their stories agree to is that they're going to Mississippi and there is a little bit of marijuana in the truck. The officer could smell the overwhelming scent of marijuana in the vehicle. He searches the vehicle and finds duffel bags loaded with marijuana. This defendant says he knew that the marijuana was in the back, but then declines to speak further about where he's going, where he met the young ladies, or anything else. The lab test is 290 pounds of marijuana.
Thank you, Mr. White. Mr. Simmons, any objection to that summary?
No, sir.
All right, then the court finds that there is sufficient evidence to convict the defendant. The court will follow the plea agreement in this case. The court convicts Steve Leonard Simmons of delivery of marijuana, 50 pounds to 2,000 pounds, first-degree felony. Court assesses his punishment pursuant to the plea agreement at 5 years confinement in the Texas Department of Criminal Justice Institutional Division. Assesses a $7,500 fine, $180 restitution, $85 reimbursement, and orders him to pay $290 court cost. And the court awards Mr. Simmons 131 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Simmons, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over with the bailiff to be fingerprinted. Good luck to you, sir.
Thank you.
Do you have anyone else that's ready and available?
Yes, Your Honor. Justin Holloman, we're ready for a plea on him.
All right, Mr. Holloman, if you'll make your way up. CR 21220, State versus Justin Lee Holloman. And Mr. Stevens, if you can give me the plea agreement.
Yes, Your Honor. He stands currently charged with a third-degree offense of assault, family member bodily injury. However, that's been reduced to the lesser included Class A misdemeanor of assault, injury to a family member. The plea agreement calls judge for, like I say, reduction to a Class A misdemeanor, 2 days in the county jail, credit for 2 days in the county jail, $2,000 fine, court cost of $270, reimbursement fees of $785, And that's the gist of the plea agreement, Your Honor. No other cases to be considered.
All right, Mr. Holloman, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. You may put your hand down. Is your name Justin Lee Holloman?
Yes, sir.
Mr. Holloman, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read signed today that you do not understand?
No, sir.
Does it bear your true and correct signature throughout?
Yes, sir.
And Mr. Stevens, do you believe Mr. Holloman to be competent?
Yes, Your Honor, he is.
Have you explained to him his legal rights?
I have, Your Honor.
You believe he understands those as well?
Yes, sir, he does.
All right, Mr. Holloman, you were originally indicted with a third-degree felony offense of assault of a family or household member with previous conviction. However, the plea agreement is to a Class A misdemeanor offense of assault. Is it assault family violence?
Yes, it is, Your Honor.
All right, so the plea today would be to a lesser included Class A misdemeanor of assault family violence, which would carry a range of punishment of up to a maximum 365 days in the county jail and a maximum fine not to exceed $4,000, to which I find that the plea agreement here of 2 days with credit for 2 days and a $2,000 fine would fit within that range of punishment. So understanding those things, Mr. Holloman, how do you plead to the Class A misdemeanor offense of assault family violence?
Guilty.
Are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court will accept the defendant's plea of guilt. Mr. Stevens, any objection to state's evidence?
No objection, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, there is an affidavit of non-prosecution on file in this case. And as such, there is no victim impact statement to be submitted to the court.
All right, thank you, Ms. Heisler. And can you go ahead and give me the summary of evidence to support the plea?
Yes, Your Honor. The victim in this cause is Mr. Holloman's girlfriend, who he was staying with. They get in a verbal altercation. He leaves and goes to work. When he returns back to the house, there is a disagreement about whether he's going to be allowed back in the house, at which time Mr. Holloman punches the girlfriend in the face.
Thank you, Ms. Heisel. Mr. Stevens, any objection to that summary?
No, Your Honor.
All right, based on the evidence, the court will find that there is sufficient evidence to convict the defendant of this offense. The court will convict the defendant of Class A misdemeanor assault. Family violence will assess his punishment pursuant to the plea at 2 days confinement in the Van Zandt County Jail. Court will give him credit for 2 days of time served. Court assesses a fine of $2,000, $270 court cost, and orders him to pay $785 reimbursement fees. Mr. Holloman, I have here on my docket that there's 3 other cases that you were ordered to pay your fines and fees on that you never did. You're way delinquent. Like over $8,000. You're aware of that?
No, sir, I wasn't aware of it, but I mean, I can set up a payment plan as soon as I get out and start paying it off.
And that's close to 100 days in jail. Do you want to go ahead and just go ahead and start setting those out?
No, I'd rather get out and pay it off. I've got a job when I get out.
Job doing what?
I'm an operator, heavy machinery.
So I'm going to order you, as soon as you get out, I want you to come over to the courthouse either today or tomorrow. And I want you to make a payment on, Cause I mean, I just added another 2,000. You're over $10,000 in debt to the county, over 10,000. The most you can get by law is $100 a day. So that's a lot of days of sitting it out. So if you don't show up, I'm going to tell you what today is. Tuesday at 3 o'clock. If you're not in the court compliance office before 5 p.m. on Wednesday, all right, then I'm just going to go ahead.
May I interject something, Your Honor? He has a parole hold, so he will not be getting out anytime soon. He's got to go back for his parole hearing, Judge.
Oh, okay. Well, thank you for letting me know that.
Yes, sir.
All right. So as soon as you get resolved with parole, then you need to report to the court compliance officer within 48 hours of being released. Start making payments on this, unless you just get habeas profiling warrants and we go through and have this hearing again. I just start assessing your jail time. Okay.
All right. Yes,
All right. All right, Mr. Holloman, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you go with the bailiff to be fingerprinted. All right, who do you have next?
Judge, I have an arraignment on the Lana Calder. However, I do not have the indictment.
Let's see what I can do for you. All right, this is cause number TR 21-322, State versus Lana Calder. Mr. Stevens, you need a moment to go over this indictment with your client.
Yes, Your Honor. Okay, so what we're gonna do is.
Right there in front of my charge. The sales tax code, what's that mean, part of my charge? That would be
Oh,
my charge. Okay.
Judge, we're ready, Your Honor.
Okay, you may proceed.
Thank you, Judge. Ms. Calder would advise the court she understands the nature and the consequences of the charges. We will waive reading of the actual indictment in open court. We'll enter a plea of not guilty to the charge.
All right, court will enter Ms. Calder's plea of not guilty into the record. Court will set Ms. Calder for pretrial hearing. Did I set you this morning, Mr. Stevens, for a certain date?
I think, Judge, let me look real quick.
Got you coming back on the 25th.
I'm on the 25th, yes, sir, that morning.
Is that, do you think that gives you enough time?
Yes, sir, I think so.
Okay. All right, court will set Ms. Calder then for pretrial hearing on January 25th. And that will be in the afternoon at 1:30 if she's in jail. It'll be at 9 a.m. in the morning if she's on bail.
Right?
Judge, I'm ready on, Mr. Kenneth White.
All right, Mr. White, CR 17-217. This is a hearing on motion to revoke. Go ahead, Mr. Stevens.
Judge, this is the first setting. I was just appointed a few days ago, and we're going to obviously ask for another court setting, and I don't have a copy of the motion to revoke anyway.
What we'll do is we'll set this on the contested docket on January 27th. That'll be at 1:30.
Judge, and I will make sure that Mr. Stevens has a copy of both of those right now.
Thank you, Mr. Woodwine.
I talked to you. Yes, sir. Thank you, Your Honor. Judge, I'll need just about 1 minute on my next client, jury 4.
Okay. All right. Thank you, Mr. White.
It'll be just a minute.
Okay.
I just want to.
Forgot who that was. Oh, yeah, I do though.
How could I have forgotten?
Whatever gets back, I'm ready.
Your Honor, we're ready.
All right, who are you ready?
Judge, it's going to be a bond reduction on a jury 4. FORE.
And Judge, before we begin the hearing, state has emailed to Mr. Stevens, to yourself, and to Ms. Taberham a proposed exhibit. Mr. Stevens, are you able to access your computer at the jail so you could see that?
No, I don't.
Okay, is Ms. Burns there? I can email it to her.
Yes.
Let me get you a copy of that real quick.
Thank you. Yes, sir.
Instead of papers over there, Karen.
Your Honor, we're ready again.
Okay. So we're going, so what did you say, Ms. Heisel, about an exhibit?
Yes, Your Honor. The state has emailed to the court and to Mr. Stevens, which has now been printed for Mr. Stevens at the jail, a proposed exhibit, which is a probable cause affidavit in this cause.
Okay. Court called writ number WR 2179. The matter of Jerry Dean 4. Do you want to call your client today, Mr. Stevens?
Yes, Your Honor, I'll be calling my client for the limited purpose of the bond hearing.
Mr. 4, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
All right, you put your hand down. Make sure you speak up loudly and clearly. I can barely hear you when you spoke just that time. If I can't hear you, I can't give you what you want. Go ahead, Mr. Stevens.
Thank you, Your Honor. It is what-
Yes,
Okay, please state your name for the record.
Jared Dean Poole,
Jerry, how long you been in jail now?
since October 16th.
Okay, and you obviously have not been able to post this $25,000 bond, correct?
No, sir.
Okay. If the bond gets reduced, who's going to help post it?
I've got family that said that they can try to help me come up with it.
Okay, and you are employed, correct?
Yes, sir.
What kind of work do you do?
I'm a tree surgeon.
Okay, and do you have your own business?
Yeah, I've recently started it. Yes, sir.
Okay, and do you, if you were to get out on bond, a lower bond, do you have customers that you can go right back to work for?
Yes, sir. I can continue to finish the job that I started, which is right in town in Grand Saline.
Okay, and my next question would be, where would you live?
I'm in Grand Saline.
Okay, and do you have transportation to get to and from the courthouse?
Yes, sir, I do.
Got transportation to get to and from to do your employment?
Yes, sir, I do.
Okay, and I think we talked earlier, and if the judge were to reduce your bond to the sum of $5,000, is that an amount that you believe your family could rake the money together to post?
Yes, sir, I believe it would be easier for me.
Okay, and if the judge does reduce it and you get out on bond, can you assure this judge that you'll make each and every court appearance?
Yes, sir, I do.
I'll pass the witness, Your Honor.
Ms. Heisel.
Thank you, Your Honor. Mr. Ford, do you own a vehicle?
No.
I'm sorry. What came after no?
Oh, no, ma'am.
And so if you were able to post bond, how would you get back and forth to court?
I have a daughter that would, make sure wherever I had to go, I went. Now you don't have to worry about that.
Okay. Do you have a residence you would be living at if you were released on bond?
Oh, yes, ma'am, I do.
And you don't have to tell me the address, but where is that? Is it here in Van Zandt County? Okay. And do you own that property?
No, ma'am, my daughter does.
Okay. Mr. Ford, have you called any bond companies in regards to your $25,000 bond?
Yes, ma'am. They wanted a excessive amount that I couldn't come up with at the time.
Okay. And do you believe that $5,000 is the most that your family could help you come up with? I believe your testimony was it would be easier for them if your bond was reduced to 5,000. But how much do you have saved up right now to go towards your bond?
Well, none, because recently, I recently, started cutting trees and stuff, and I had to go out by rope. I had to go out by saw. So and she even helped me do that. I still owe her some money on it. So, she's being more than understanding on it and willing to stand by me on this. And, she's a mother to, she has a child. So, she's going to be straddling responsibility of helping me get out and making sure I come up to court and make sure I don't miss no court, docket calling or anything like that, plus helping me get out. So, and plus, she told me if she had to, that she would, start coming to work with me to make sure that I didn't get in trouble or anything, which I'm not planning on doing.
All right, that's good to hear. Your Honor, I'd pass the witness.
Mr. Stevens?
No further questions, Your Honor.
All right, state, do you have any evidence or want to call any witnesses?
Your Honor, the state would just offer proposed exhibit 1, which is the probable cause affidavit for the arrest of Mr. Ford.
Any objection?
No objection.
All right, state's exhibit 1 is admitted. And do you want closing argument, Mr. Stevens?
No, Your Honor, you've heard my client testify. He does have family support. He has ability to go back to work, get to and from the courthouse. When he and I visited earlier in the jail, he said that if you reduce it to 5,000, he knows his family would be able to post that bond to get him out. So we're respectfully, Judge, asking the court to reduce it to $5,000.
Ms. Heisel?
Your Honor, the state is somewhat conflicted on this. Mr. Ford has been in for less than 60 days by our calculation. However, given the grand jury schedule because of the holidays, I don't believe that we can have him indicted by 90 days. So I would offer that to the court for its consideration. Because of that, the state would be willing to agree to some bond reduction because we do believe he is going to become entitled to that here in the near future. However, the court has before it the affidavit of probable cause wherein Mr. Ford admits to the conduct that he's charged with, which is a violent offense. And so while we do agree to a reduction, we believe that a reduction down to 5,000 may not be sufficient enough to protect the community. So we would ask that the court reduce his bond, but reduce it somewhere in the $20,000 range.
Let me ask. Let me ask, is Mr. Ford a wanted man out of the state of Colorado?
Do you have any wants or anything in Colorado?
Well, no, Your Honor.
Say that again?
No, Your Honor.
You don't know?
Oh, I am not.
Oh, you're not? Okay.
That's right.
My inmate bonding information form says that you have 3 charges: aggravated assault with a deadly weapon, theft from a person, and robbery. The latter 2 being charges out of Whitfield, Colorado.
No, Your Honor. Wrong state. That's, I don't know, what was that last one? Aggravated what? It should have been. No, there's no warrant. There's no active warrant.
Robbery and theft from person.
No, sir. No, sir. I've never been in Colorado.
You said I had the wrong state. What state do you think you may be held out of?
No, I mean, I've never been to Colorado. That's why I can't understand. I don't even know what y'all are talking about. What is it?
I don't have anything.
Oh, can you read them back to me again?
I sure can. Aggravated assault, deadly weapon, Van Zandt County charge. That's what we're here in court on today.
Okay.
Theft from person out of Whitfield, Colorado, and robbery out of Whitfield, Colorado. Is there someone there at the jail that I can speak to determine whether or not there's been a confirmation on warrants from Whitfield, Colorado?
Are you stepping back there, Ms. Peg? Thank you.
He's being checked on, Your Honor.
Thank you, Mr. Stevens. Because if it's a mistake, I want to be able to disregard it and mark it out, move on.
Your Honor, this is Officer Sneed. She's got some information to share with you, sir.
Hi, Officer Sneed. How are you?
I'm good. How are you?
I'm doing great. I'm trying to determine whether or not I had some information written on my inmate bonding sheet that Mr. Four here, we're dealing with his aggravated assault deadly weapon charge out of Van Zandt County, but this sheet is also showing that he is a wanted person out of the state of Colorado for theft of person and robbery. Do you have more information on that?
That is out of Georgia, actually. It is, well, yes, ma'am. It's Whitfield County, SO, out of Georgia.
Okay. And so have we done any type of extradition on Mr. 4?
No, sir. Since he is still here on our charge, we have not done extradition paperwork yet.
Okay. All right. All right. Anything else that you have? So is my information correct? Theft of person and robbery?
A robbery, theft by taking, probation violation out of Whitfield County, Georgia. Yes, sir.
Probation violation. Okay. All right. So there's probably not going to be an extradition because he's probably going to get sent back on interstate compact. There is no right to extradition on that. So, okay. All right. Thank you very much, Officer Schnee. I appreciate your help.
Not a problem.
Okay. All right. The court is going to deny the request to have the bond reduced at this time. How many days has he been in custody, Mr. Stevens? 50?
I don't know the number of days, Judge, but about since October the 16th.
October the 16th. So he's not yet to his 90 days. Is that correct?
Not yet 90, Judge. No, sir.
And that's what you were saying, Ms. Heisel. He may breach his 90 without getting the grand jury.
That's correct, Your Honor. I believe that to be the case.
All right. So at this time, the court's going to deny the writ and seeking bail reduction, and the court's going to find that at this time, $25,000 is not excessive in order to secure the defendant in this jurisdiction, in this court, and protect the community. If Mr. Ford reaches the 90 days, then counsel will contact the court, let me know that he's statutorily entitled to it.
Yes, sir. Thank you, Judge.
All right. Thank you, Mr. Stevens.
Okay. Judge, that's all I have. Might be excused.
Yes, thank you, Mr. Stevens.
Thank you, Judge.
Your Honor, Mr. Ashmore should be done, but let me go double check on him, sir. Your Honor, Judge Martin.
Deputy McLeish, should be just a moment.
Yes, sir.
All right, Mr. Ashmore, are you ready?
Jail court is muted, Judge.
Yes, ma'am.
All right, is this Mr. Poche?
This is Mr. Poche, Your Honor.
Is it Joshua Francois Poche?
It is, Your Honor.
All right, Mr. Poche, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down. Mr. Poche, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yes, Your Honor.
Have you ever been diagnosed with any type of mental condition?
Yes, Your Honor. PTSD through the VA.
And are you currently undergoing any type of treatment or on any type of medication for PTSD?
Yes, Your Honor, both.
All right. Do you feel that that treatment and medication are enabling you to have a rational understanding of today's proceedings?
Yes, Your Honor.
You don't feel like you're suffering from PTSD or any of the effects of it in such a way that would prevent you from having rational perception and thought today, are you?
No, Your Honor.
Okay. In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with Mr. Ashmore's representation of you?
Absolutely, Your Honor.
And do you feel like you've had enough time to discuss the case with him and have all of your legal questions answered?
Yes, Your Honor.
Mr. Ashmore, do you believe Mr. Poche to be competent today?
I do, Your Honor.
And have you explained to him his legal rights?
Yes, Your Honor. I have. I'm sorry, go ahead, please.
No, go ahead. You can elaborate.
Well, Judge, Mr. Poche is charged with possession of controlled substance. He doesn't have a lengthy criminal history. He's a combat veteran, served in the War on Terror. We've discussed the pros and cons of accepting this as a time-served offer. Mr. Poche and I have discussed at length Veterans Court and other options, the Valor Program, and we have come to the conclusion that this is the best course of action with the challenges he has. He's set to check into the Bonham Veterans Affairs Clinic once he's done with his business here. And I don't know when that will be, but it'll be, they've got a bed there for him or are working on a placement for him there for the PTSD clinic up there. And this is the fastest way to get to that solution, Your Honor. So we've discussed all of that, all the pros and cons. I've spoken to his mom and dad, and this is this is a course of action we're asking the court to review.
All right, Mr. Poche, you are charged by indictment with the state jail felony offense of possession of a controlled substance in penalty group 2, less than 1 gram. The state jail felony in Texas carries a range of punishment of confinement in the state jail division of TDC for not less than 6 months or more than 2 years and a fine not to exceed $10,000. I see the plea agreement is that you would plead guilty to that charge in exchange for the state's recommendation that your punishment be assessed at 6 months confinement in TDCJ, a $2,500 fine, $180 restitution, with the state asking the court to take into consideration and dismiss DA possession of marijuana, 2 ounces, but less between 2 ounces and 4 ounces. Also see that you would have 180 days credit towards that sentence for the time that you've already served in custody. Is that your understanding of the plea agreement, Mr. Poche? All right, Mr. Poche, how do you plead to possession of a controlled substance in penalty group 2 less than 1 gram? Guilty or not guilty?
Guilty, Your Honor.
And Mr. Poche, are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty to this charge today?
No, Your Honor.
All right, the court will accept the defendant's plea of guilt. Mr. Ashmore, any objection to the state's evidence?
No, Your Honor, we have no objection.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor, we would rest and close.
Mr. Ashmore, anything further from the defense?
No, thank you, Your Honor, for the additional time to work with Mr. Poche today.
All right, state, can you give, well, actually, I've got the evidence here, I believe.
I have a summary for you, Judge, but if you've got it, then that's fine.
Yeah, I won't make it work any harder than you already do. Let me read for myself here.
I'd have to try to decipher Miss Heisel's handwriting, but I think I could do it if you need me to.
That's okay. I've seen her handwriting. I better go with what I got in print here. All right, based on the evidence, court finds that there is sufficient evidence to convict Mr. Poche of this offense. The court will follow the plea agreement between the defendant and the state. The court hereby convicts Joshua Francois Poche of possession of a controlled substance in penalty group 2 less than 1 gram. Court assesses his sentence at 180 days confinement in the Texas Department of Criminal Justice State Jail Division. Court awards him 180 days credit towards that sentence for the time that he has spent in jail on this cause. In addition, the court orders him to pay a fine of $2,500, $180 restitution, $85 reimbursement fees, and the court takes into consideration and dismisses cause number DA 2020-49 of possession of marijuana between 2 ounces and 4 ounces. Mr. Poche, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I wish you luck, and I do thank you for your service to our country.
Yes, sir. Thank you, Your Honor.
You're welcome.
Mr. Poche?
I'm gonna call you the secretary. Okay, and then it'll be some coordination. I don't know what.
Judge, that should finish us up.
Well, I do want to talk to Mr. Ashmore before we're done. Not done with him yet. Hey, do you have to get back to the office quickly, Casey?
Oh, do you want me to come to the courthouse?
Oh, yes, I do, please. I got a present for you.
Thank you, Mr. Poche. Good luck.
It's gonna be an early Christmas present.
No. Yeah.
Casey, run back to Rockwall. Do not fall for that. I don't know what it's about. Do not fall for that. That is not in your best interest.
Well, if the state's prosecutors wanted to come over, they may be interested as well.
I'm sure one of us will join you, Judge.
Yeah, we have to have signatures.
One of us will be by shortly.
All right, see you then. All right, that will conclude our docket today. We will be adjourned. We will return on Thursday,